yourself a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Your lawyer is in and he's relaxing in a lounge chair, although his mind is on high alert, ready to take your calls and answer your questions. I've got a couple of lines free, 1300 222 774, if you would like some legal help from David Whiting. David, good morning.
Good morning, Virginia.
What's happening in your world?
Things are quiet at the moment. The town is still down. I've been having a look around at see what office rentals are. We're in negotiations with the landlord at the moment.
Are you?
Office rents are generally less than they were last year. And the suggestion was something like 20 or 25% of shops are available to rent. So
interesting.
It's a very interesting. Yeah, I think. My difficulty is that I don't think that you can bring somebody on at home. They've got to be, for them to be part of your culture, you need them there and you need them in the office.
I agree. I think it's also terribly dispiriting and lonely for the person who's starting the job.
Yes.
To be working from their lounge room.
With no co-workers, as it were.
No, absolutely, yeah. So you need new office space because you're expanding?
My lease comes to an end in March, and it's the negotiation stage at this stage.
I'd love to see you in negotiations.
Quite like the space I'm in. You know? Just can't tell the landlord that. That's all.
No, don't. They're not listening, I'm sure.
Yeah.
1300 222 774. I mentioned on air yesterday, I said, that's an issue we really should put to David tomorrow. I'll do that. Do you think I can remember what it was?
You will during the course of the next 20 minutes. So
I've been trying for the last 20 and I can't.
Okay.
Do you reckon someone might help me?
Oh, well, I'm sure they will. But I can remember one from last week.
What was that?
Len from Viewbank. Len lives next to a council reserve, and there's some trees crushing his property. And the question was, does the council have the same obligations as other landowners? The answer is yes, except where it's in a road reserve. But because he was living next to a park, the council presumably where he was talking about, has a responsibility in the same way as every other tree owner does.
Okay.
So I can fix Len from last week. All you need to do is remember yesterday will be fine.
It's not going to happen.
Okay.
I'm going to need the lovely listeners to sort me out. Were you listening yesterday? What did I say? Honestly, my brain is so addled at this point of the year, and after the 2 years that we've had, I can barely remember my name, and that got me into trouble on TV once upon a time. 1300 222 774 is the number here. We'll start with Steve in Footscray. Good morning, Steve. How can we help?
Hi, Virginia and David. Look, we've got a building project which is 3 years over its completion date. I've had the building surveyor down on site, and they were issued a building order to be fulfilled by the contractor. The building contractor hasn't fulfilled that, and it's been referred to the VBA for issuing, I suppose. There's a couple of questions here. As well as that, I've had the dispute with the DBDRV, and because of the building order
I have a view, Steve, that the Domestic Building Dispute Resolution Victoria is like walking into an office with a hidden queue. You know, you take a number and you've got no idea how far away you are from the head of the queue. It's a queue before you queue at VCAT. Anyway, would that be a fair assessment?
Oh yeah. Look, I've been in the queue for 3 years, so I can agree with that. But so with the VBA, my first question was, can they enforce the order to be fulfilled? I know there's they'll assess it and see if there's a fine applicable, but can they also enforce it to be fulfilled? And with the DBDRV, is my next step to take it to VCAT and issue a point of dispute? And
yes, in terms of your dispute resolution, the DBDRV, the next stage is you get a certificate from them which allows you to take the matter to VCAT. So your answer is yes, it's an action against VCAT. Now, the general proposition in relation to, so let's take the VBA matter first. It will, if they can prosecute and there can be a fine, and they can cancel or suspend the contractor's registration as a consequence for not getting it done. The financial consequences for not doing the work are dealt with in your VCAT matter.
But what about actually just getting the job finished, Steve? I should imagine that'd be a big pressure for you right now.
Yes, I need to know, do I need to then lodge that as one of my points of dispute with VCAT, is to address the issues in the building order?
One of the answer would be yes, you would. I would be coming along, because the building order is a defect in the building. It's a defect in the process that's not been attended to that will give rise to a claim for damages.
Okay.
Yeah.
Hope that's helpful, Steve. Good luck. It sounds like a terrible position to be in. Anne in Ballarat, how can we help?
Yes, Virginia and David. I'd like to put my husband Ian on because he can explain it better for me.
Okay.
Is that all right?
Sure. Go ahead, Ian.
Anne's mum bought into an assisted living retirement village.
Yes.
Years ago. 2 years after she went in, a bigger company bought the place, and by stealth they've changed it to independent living. And there's only one staff member, and that's the manager. And the manager's only there between 9 and 5, Monday to Friday. The point is that she's not getting the service that she paid for.
Yes.
And the current owners don't want to know. We've had numerous exchange of letters and get no positive feedback.
So why don't you, Ian, price the cost of the services that you're not getting and put that in an A? I mean, at the moment you're whinging is the wrong word, but you're complaining that you're not getting what you contracted to get.
That's right.
Yeah. So where you go from there is you say, well, what would be the cost of bringing in these additional services? And I would be saying to the crowd that now owns the village that your mother-in-law is in, is that's the cost of replacing them. Tell me why you shouldn't be paying that amount of money, and you might also have an action for breach of contract.
Right. There are 3 ladies in the same position where they've been denied service. It amounts to another staff member, essentially.
Ian, so when Anne's mum went in, she believed it was going to be assisted aged care.
Yes, not aged care, retirement.
I'd ring the myself. I'd ring the Aged Care Quality and Safety Commission. I mean, this is a reportable matter.
Wrong crowd.
Why?
Because the aged care people look after people who've moved into care, so they're in an aged care facility, a nursing home. What we're talking about here is a retirement village where there's a button on the wall or you wear a pendant, so if there's a crisis at 3 o'clock in the morning, someone will come. All right, so it's that kind of support. It's not nursing home support. Nursing home support, aged care facility support, you definitely ring the aged care hotline.
Yeah.
These people are governed by the Victorian Retirement Villages Act, but from Anne's mum's point of view is she contracted to have a bundle of services available. The catch that you've got, Ian, is that if you read the contract that your mother-in-law signed carefully, you'll find that there will be a clause in it that says that if they get medical evidence that says that your mother-in-law is no longer fit to stay in the village, then the contract comes to an end. So you might. I would be suggesting you get some advice in relation to the contract, the consequences for bringing it to an end, because that brings forward the deferred management charge, which will take potentially 25% of the value of the unit when you leave. So I would be inclined to start by pricing together with the other. If there are 3 residents there, price what the services would cost to replace. And that's your bargaining point with the aged care provider, with the retirement village operator.
A terrible situation to be in. I'm sorry to hear that, Ian, and I hope that's helpful. Thanks so much. Good luck. Is there some sort of ombudsperson, though, or authority that one could go to in Ian's situation and let them know that this change had been made and that it was unacceptable and not the agreement that had been made originally?
Don't know. I don't think there is, because I think that...
Is there state authority?
But there's legislation that says these rules apply, but they more relate to security of tenure, so you don't get thrown out, rather than... because if you think of aged care, there's a set of 45 aged care standards that every provider needs to adhere to. For these kinds of independent living arrangements, it's they contract to provide a series of services, so it's a contract matter. But I'll look for next week. Linda
in Fitzroy, what's your problem? Good morning.
Oh, good morning. Hi. Mine's a quick one, I hope. I put a deposit on a piece of furniture in a store, but changed my mind about it. It was being delivered from another store, not being specially made for me or anything. So anyway, I asked for my deposit back, but they'll only give me a credit note. And I'm just wondering what my rights are there. Can I push for my money back?
You can push for your money back, but you can't insist on your money back. The buyer protection that you get under the Australian Consumer Law is designed to ensure that you get what you contracted for. It's not designed to give you a cooling off on every decision that you make to acquire something. So if you agreed to buy X armchair or X sofa or X dining room table and they've got it and you're happy with the delivery terms, then that's really the end of the discussion. There are lots of big stores which will allow you to change your mind, but that's a customer goodwill exercise rather than a contractual obligation.
The furniture hadn't even been delivered to the store where I was going to buy it from.
No, I understand, but you had... It's like buying a car. You go in and you sign a contract to buy a car, and you may not see that vehicle for 3 months. Kind of makes your argument the same, and once you're committed, you're committed.
So it looks like it might have to be a credit note then, David?
Yes.
Yep. Okay. Sorry we can't help there. Joy in Greenvale. How can David help you? Good morning.
Good morning, David. David, I know somebody who is has been embezzling some money from the company that he worked for a long time, and it's a lot of money.
Yes.
The company that he worked for is now suing him as a civil matter. And I'm trying to understand, if you can explain to me, why they wouldn't get the police to do this. And if it is done as a civil matter, can you still go to jail?
You don't go to jail as a consequence of it being started as a civil matter. So if someone is an employee and they steal, yes, it is possible to report the matter to the police. If the matter then goes to court, it's possible to seek an order for restitution, and the order for restitution is what you make an application for. But at that stage, that's a discretionary remedy that the court may make. Your person's employer has decided that they will, whether they've reported the matter to the police or not, have decided to commence civil action. The police one's a bit fraught because sometimes there might be 27 allegations of theft, and the police will, if you plead guilty to 5, will forget the other 22, and then the court will take into account the fact that there are 5, but there are other similar matters. But you're never on that basis going to get your compensation order based on the 27. So I think and it's also that depending upon the complexity, it's actually very difficult for the police to allocate the resources that are required for this kind of matter. If there are lots and lots of individual transactions, you will find that quite often the police are unable to devote the resources that are needed to see a prosecution through.
Okay, so in making it a civil case, they would be looking for restitution, but what if there can't be any restitution, that this person has actually nothing? The money is completely gone.
Joy, can I tell you that debtor prison is gone, so he's not going to go to jail as a consequence of a judgment under this that he can't fulfil. What then would happen would be they would have the ability to make a decision that he'd be declared bankrupt. But you've said he doesn't have anything at the end of the day.
Okay, all right.
Are there criminal matters proceeding or possibly going to proceed as well, Joy?
I don't think so at this point. It hasn't been mentioned.
Okay.
They're just pursuing it as a civil matter, and I keep feeling that they're looking for restitution, but there can't be any because the money's gone.
Joy, can I also say that it's actually an offence to conceal a crime? That's not the same as not reporting it, but it's to conceal a crime is an offence. So if the employer says to the employee, give me the money back and I won't report it to the police, that's concealing a crime. Right? So it's a very, from the employer's point of view, it's a very delicate position to be in.
Difficult situation for you and your friendship with this person, Joy. Thanks for calling in this morning. Jess in Kensington, good morning. Go ahead.
Hi there. My query is about property and the landlord for a house that's behind my house.
Mm-hmm.
They have a kitchen window that overlooks into my backyard, The landlord is the Department of Housing, and recently there was an incident whereby the tenant opened the window because they were angry at the noise that was being made from my property and threw objects at me and engineers that were in my property. That's going to be demolished and rebuilt. I've requested, obviously, I've gone through legal channels for that matter. That's completely different. I've requested that the Department of Housing change the window to a fixed opaque window to ensure future safety, especially because they're the landlord and they're responsible for the actual
can I ask,
building fabric.
Jess, how long has the department been the owner of the house?
Since 1996, when all of the houses were built.
For 25 years, no one's done what this person has done, and you want the property altered because one person did one thing.
The person has a tenuous aggressive issue. So in order to get them evicted would be going through those channels, which I am pursuing, which is not the basis of my query. My query is that given that there is a potential future safety to me, my person and my family, because I also have a child, the overlooking is such where he literally can hit us even if we are inside our house from his window. So
this is in the new house you're going to build, is it, Jess?
It's a current dwelling that we're going to demolish.
Yes.
And then build a new house. So we have been living there for 7 years. Yep. Now we're going to demolish it and build a new one.
I do not believe you'll succeed in an application to get the ministry or the department to redesign the kitchen as a consequence. I mean, if you're concerned, what you might suggest is that and I would have thought a kitchen with a window that would open would be of real benefit. So I would suggest that you might consider some kind of grill or framework to make it harder to throw things out, but I just don't see you succeeding in an application I don't see you persuading the department to change the premises because of someone who they might choose to reside there.
And up until now, it's never been an issue, Jess. It was just that one instance David is suggesting as well.
No, so there have been instances since. It's just that was the precursor.
Okay.
Then but I think the better answer would be if you would. Why don't you talk to the ministry about getting them to move the tenant? Is where I would probably. That seems to me to be the easiest way to resolve the issue.
I think there was some mention there about some eviction, but Jess, we'll leave you to figure that out. But that's David's best advice at the moment. Thank you so much, Keith in Sunbury. Good morning. What's going on?
Hi, Virginia and David. Thank you for taking my call.
It's all right.
We've got a similar request to a gentleman that rang in earlier about his contract to sale. We've entered into, or my stepdaughter has, a contract to sale to a house and a land package in Bendigo, this is. Now, the builder, we applied for all the loan, which was approved. We also applied for the grant, for the federal government grant of $25,000. Because of the time delay, it dropped down to $15,000. But the builder hasn't commenced that project and was supposed to be started by March, the end of March, so that we qualify for the loan. And it was going to be completed in August this year. And he hasn't commenced and done any of the works at this point in time. All he did was scrape the block of land and said, well, he had started, but there's been no other works done on the block. And we've been going through solicitors and getting no satisfaction.
Keith, I've got some notes of what we talked about. It seems to me that there are two questions. First of all is the ongoing eligibility for the grant that you've got and the consequences of changing a builder and its effect on the grant. So you certainly would have the right to terminate your agreement. Sorry, is the plan of subdivision being registered? Is the block your child's yet?
Yeah, the block of land, it's all part of the contract to sale. The block of land is in his name, the builder's name.
Yes.
So it was a house and land package and being constructed by the builder. And my stepdaughter was purchasing that.
But Keith, that will have been conditional upon registration of the plan of subdivision. Are they out of time for plan registration? What do you want to do, I suppose, is the question?
No, sorry. The plan of subdivision has been approved. It's all complete.
So, but let me ask you, what does your daughter want to do?
She wants to complete the house and land package because she has a fixed price contract, and of course prices have gone up.
Yes.
And but she's being disadvantaged by continuing to rent. She wants the completion of the house and land package, the construction part, to be completed.
Okay. Then I would start, Keith, with getting some quotes for a replacement builder, just so that you can quantify what your loss is in a discussion you have with the builder. I mean, from the builder's point of view, he may be losing money as a consequence. As a result of prices going up since March, I'm absolutely certain that his building costs will have gone up 15 to 20% since then.
Okay.
So it might well be that the builder's saying, if I can persuade Keith's stepdaughter to go away, I won't lose any money on this block.
Keith, I hope that's helpful. Lisa in Druin West, go ahead. Lisa, you there? I don't think...
Lisa might have been reminding you about yesterday's call.
No, others are reminding me, but even their reminders still don't remind me, so we've got a real problem going on here. Marianne in Beaufort, you'll be our last call. Go ahead, Marianne.
Thank you for taking my call. I'm in a building dispute which has been going on for nearly 4 years now with an architect and the builder who left us with a house with about 200 defects, and we have no compliances to finish the building and no one will touch it. A barrister told us last week the builder and the architect have both gone into liquidation and have gone into new businesses under new names.
Yep.
And our barrister said to us last week that even if you win, that how are you going to get the money out of them, that you may not ever get any money? And I'm just wondering...
Marianne, that makes no sense to me.
Okay.
We have building insurance. Both of them will have had insurance. Mm-hmm. And so you had an architect supervised contract and a builder who didn't deliver.
Yeah, and the architect was the project manager.
I would be looking at the builder will have insurance. Even though the builder's gone into liquidation, the kind of insurance that builders get, it really assists people like you in circumstances where there is a liquidation. So I can't understand how there would be a builder in those circumstances who wasn't insured. So I'm not saying that you'll get 100 cents in the dollar. I'll all but guarantee that you won't. But that's where I would be looking. So I'd be going back to the barrister and say, well, what about the builder's insurance? It mightn't give me 100 cents in the dollar. Beg your pardon?
And the architect?
I'm not sure what the Building Act says in relation to insurance for architects, but I'm sure there will be some.
Okay.
Right.
I hope that's helpful. David, I remember my question. In fact, I didn't remember. The dear listeners did. Thank you so much. Travel insurance related to COVID. People now being asked when they go for travel insurance, detailed questions about their age. Have they had COVID? Are they vaccinated? What do people need to be aware of when they're trying to get travel insurance?
There's a concept in insurance law called ubere fide, of the utmost good faith.
Yeah.
And if you lie on an insurance application, the insurer is entitled to deny cover. So tell them what they ask if you want the cover.
Are you aware of insurance companies saying, sorry, we'll give you travel insurance, but we're not going to cover you for any COVID-related matters?
Yeah, there's lots of doing those, and there are some countries that won't let you in unless you've got $30,000 or $40,000 of COVID-specific cover.
Oh, interesting. Okay,
Yep.
So it's actually a buyer beware situation. You need to check it out carefully.
Absolutely.
And try and find the place that'll cover you if the first one won't.
Yes, and just see what the premium is.
Thanks so much.
Yeah.
See you next week, David. David Whiting there, helping you with legal problems.